yeah, democracy.
Oh yeah, it was really cool. It's a really good idea. I really like it.
Honestly, the best.
Socialism! Yay!
This smells like anarchy. You're under arrest.
Gitlow versus New York took place on June 8, 1925, and decided that the 14th Amendment extends the reach of confines of the federal government, in which was catalyzed by the First Amendment's freedom of speech and press. Mr. Benjamin Gitlow was an advocated member of the Socialist Party of America and had charges made against him in regards to criminal anarchy under the New York Criminal Anarchy Law of 1902. Due to his publication of the Left-Wing Manifesto in a newspaper that went by the Revolutionary Age in July of 1919, this manifesto claimed that socialism can be achieved through strikes and class action. In 1920, Mr. Gitlow's trial spanned January 22nd to February 5th and declared that his left-wing manifesto was not a declaration to overthrow the government, rather a simple analytical approach on history. Mr. Gitlow was declared guilty 6 days after his last trial, but only spent 2 years in prison before he was released on bail. However, his conviction was upheld 7-2. In 1833, the Bill of Rights were meant for the federal government, only giving the states the ability power in which federal government could not inhibit. However, due to Gitlow versus New York, that took a rather drastic change and determined the Bill of Rights applies to the states as well as federal government. The Due Process Clause of the 14th Amendment was used in protecting the freedom of speech and press that the state diminished by taking away Gitlow's life, liberty, or property. This court case served as an incorporation doctrine, which means that the Supreme Court has taken specific rights within the government's Bill of Rights by making them into liberties protected by the 14th Amendment. Nevertheless, the court still convicted Gitlow on the behalf of quashing and punishing speech that encourages the overthrow of the government in a violent nature, in which the manifesto had portrayed. Bandis and Holmes, two men who argued on behalf of Gitlow, claim that Gitlow acts as no threat due to the small amount of supporters. In addition, Gitlow stated that his manifesto did not encourage any action, giving the conviction no concrete support. The outcome resulted that states had the power to ban texts and talks that had the potential to encourage harmful actions.
Alabama arrested Martin Luther King Jr. 7 times?
No, it was only 4 times! Who endorsed this?
Ralph Abernathy, SSCA Senior, Mr. Shuttlesworth, and Joseph Lowery.
Smells like libel!
Heed Their Rising Voices was an advertisement put out by the New York Times on March 29, 1960, in which stated declarations for Martin Luther King Jr. in protection against the Alabama pre-jury indictment. The Alabama police force of Montgomery are said to have been unlawful against civil rights activists. Under Alabama law, one does not have to prove that alleged statements have harmed them in order to file a libel. However, the New York Times claimed that MLK Jr. was arrested 7 times, when in truth it was only 4. Therefore, Mr. Sullivan, the Montgomery Public Safety Commissioner, claimed that this false accusation vilified him in their advertisement. Although Mr. Sullivan was unnamed in the advertisement against the police force, he followed a libel against the paper and the 4 ministers who endorsed it, due to his responsibility of overseeing the police force. The state's law denied the libel action unless there was a public retraction of the advertisement in which Sullivan requested. It was unsuccessful. The New York Times were confused as to why Sullivan thought the statements were any reflection of him and his job, and Sullivan filed yet another libel suit a mere 2 days later, winning $500,000 in the state's court. The Times still did not retract the advertisement until John Patterson, the governor of Alabama, demanded the post be taken down, and ruled because he represented the state as an Alabama official, the Times listened. The court ruled 9-0 for New York Times versus Sullivan, for the First and 14th Amendment protect the freedom of speech and press. No matter if false or not, the two amendments protect the statements except if they do not pass the actual malice standard, in which claims that it is a publication is made with the knowledge that the statement is false, then it is not protected, with no evidence that the Times posted the advertisement with actual malice. Mr. Sullivan had no hope of winning the case.
Look how disgusting it is! All the dirt in the water! I can't dock any of my ships because of this! Ugh. Oh, look at this. This amendment says I have a right to my private property. Ah.
Silly boy, the Fifth Amendment only restricts the federal government.
Ugh.
I, Baltimore, can do whatever I want with your war.
Hold your horses, Baltimore. According to me, you cannot deprive someone of their life, liberty, or pursuit of happiness without due process of the law.
Barron versus Baltimore, Supreme Court Case 32, took place in 1833, in which constituted the Bill of Rights only limits the power of the federal governments, not the states. John Barron of Baltimore owned a wharf on the harbor, but when the city started to industrialize, many tons of sand and dust built in the water surrounding the water, therefore making it impossible to dock ships. Mr. Barron stated that Baltimore violated the Fifth Amendment, which states that without the cause, the government has absolutely no right to confiscate privately owned property. Barron won the case, so much so that the Supreme Court did not even hear the arguments of Baltimore's defense. Mr. Barron was given $4,500 from the city for compensation, in which he then appealed as the Supreme Court in 1833. However, when Chief Justice John Marshall came with a decision, he claimed that Mr. Barron had not a validated argument because he had no claim against the states because the Bill of Rights only applied to the federal government and not the states. The Fifth Amendment could not apply to his case because it only acted as something to restrict the federal government, not the states, concluding that Mr. Barron's case was dismissed due to the lack of jurisdiction. Barron v. Baltimore is a shining example as to why the U.S. needs to have the 14th Amendment, in which defines that states cannot deny the people of life, liberty, or the pursuit of happiness without due process of law. This led to the reform in which now the state governments have no right to take privately owned property without reimbursement.
Where?
Under arrest. Okay.
Smells like no one cares about your free rights. Classic interrogation style.
Miranda v. Arizona was argued on February 28, 1966, and decided June 13, 1966. Miranda v. Arizona ensures that the accused is aware of their rights and can use them anytime while interrogated, otherwise it will not be allowed to occur. Ernesto Miranda had been given incriminating evidence without notification of his right to the Fifth Amendment of the Constitution. The defendant was arrested because of incidental evidence connecting him to the rape of a 15-year-old girl. He was sentenced to 20 to 30 years of imprisonment. The Supreme Court, however, said that his constitutional rights were not violated in the interrogation that led to the confession. However, Mr. Miranda had signed a statement 2 hours after the interrogation, saying that he was aware of his rights. From now on, a Miranda warning is given by the police to criminal suspects. This informs individuals of their constitutional right before their interrogation and arrest. This was actually one of 4 cases regarding admissible of evidence during police interrogations. The second defendant was Michael Vigdinra, who was arrested for robbery. He only admitted the robbery to the first officer, and no evidence that he was notified of his Fifth Amendment constitutional rights. The third defendant was Carl Calvin Westover, who was arrested for 2 robberies. After 14 hours of interrogation, he signed his confession. The fourth defendant was Ron Allen Stewart, who was arrested for the stealing of purses along with his family. After 9 interrogations, Roy admitted to the crime. All of these defendants should be aware of their Fifth Amendment constitutional rights, that is, the right to remain silent. Tom Clark argued against this rule, stating that there is not enough evidence to justify a new rule. John Harlan also argued that the due process clauses should apply.
You have the right to remain silent.
I am no way connected to President Nixon. No, nuh-uh.
This smells like overstepping your executive privilege.
On the night of June 12, 1972, 5 men were arrested after attempting to bug the headquarters of the Democratic National Committee at the Watergate Hotel and office building. These men were later linked to high-ranking officials within the Nixon administration who were responsible for the planning, execution, and cover-up of the bugging. Over the course of 2 years, Nixon himself was implicated in ordering the cover-up of this scandal. As a result, Nixon resigned from office before any criminal charges were enforced. It was further found that Nixon had secretly tapped all conversations that took place in the Oval Office, which gave the grand jury the ability to subpoena all relevant tapes to the Watergate incident in order to investigate executive responsibility. Is the president's right to executive privilege immune from legal consequences? The District Court of the District of Columbia, represented by John R. Searcy, rejected the claim that Nixon had inherent executive privilege that protected the secrecy of the conversations held in the White House. In response, Nixon argued that the president was not subject to regular legal standards and could not be tried by a judicial system because of the separation of powers. He believed that the impeachment process was put in place for this purpose. If a president committed a criminal act or an abuse of power, he or she could be impeached but not legally tried. The courts found that the president was not above the law. They held that neither the doctrine of the separation of powers nor the need for confidentiality within high levels of government was sufficient to protect the president from legal punishment. Although executive privilege is indeed granted to the presidents of the United States, it must be limited. The court ruled on limited executive privilege in areas as military or diplomatic affairs. However, due process of the law took precedent above all else. Because of this ruling, Nixon was forced to hand over the tapes to and documents in accordance to the subpoena issued earlier.
Can I help you?
Let me in!
Whoa! Whoa! Oh! May you please enter the premises?
No, you do not. You don't have a warrant.
Oh yeah? Let's go. I have a warrant for your arrest!
This is a fake warrant.
No, it's not. Hey, that's being belligerent. You're under arrest. Let's go.
smells like porn.
Map v. Ohio was resolved in 1961. Dalry Mapp was arrested for the legal possession of pornographic materials. The case first tried in the Metropolitan Court of Cleveland. Then it was appealed first to the Supreme Court of Ohio, and then the Federal Supreme Court agreed to hear the case on March 29, 1961. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Dalry Mapp and her attorney argued that because the police did not possess a legal warrant, any incriminating evidence that was found during the unconstitutional search should not be used during the trial. The state of Ohio argued that it was only the breaking in and entering of Mapp's house that was unconstitutional, not the inclusion of the evidence in a court. Also, the 14th Amendment does not prevent the admission of evidence obtained by unreasonable searches and seizures. The majority opinion issued by Justice Tom Clark stated, "We hold that all evidence obtained by searches and seizures in violation of the Constitution is inadmissible in a state court." However, the minority agreed that the verdict of the Wolf v. Colorado case, which allowed the admission of evidence found during an illegal search in a court of law, proved the evidence admissible. The Supreme Court voted 6-3 in favor of Mapp. As a result of the Mapp v. Ohio decision, evidence gained by an illegal and unconstitutional search became inadmissible in state courts.
Hi, I want an abortion.
Were you raped or is the fetus of incest?
Yeah, I was raped.
Prove it.
I can't, just take my word for it.
No!
This smells like a violation of women's rights.
Norma McCorvey, who in 1969 got pregnant and sought an abortion in the state of Texas. At the time, the only exceptions were for rape and incest, so she was denied of the abortion which she wanted. At first she claimed that she had been raped, but could not prove that she was, so she had to drop that claim. By the time that this court case goes to the district court and the Supreme Court, McCorvey had already had the kid. In the district court, Roe is arguing that abortion should be a guaranteed right under a number of amendments made to the Constitution. She uses the First Amendment in the Establishment Clause, and the abortion laws are based on religious beliefs. The Fourth Amendment, which states that one has the right to be secure of their persons. The Ninth Amendment, that the undefined rights not mentioned in the Constitution. And the 14th Amendment, which makes this case a federal case, that no state shall deny life, liberty, and the pursuit of happiness without due process. In this sense, Roe is arguing that these amendments combined create a zone of privacy for the American people. However, the state is arguing that that abortion should be illegal everywhere, but rather that this is a state matter under the 10th Amendment of the Constitution. Therefore, it should be left up to the people to legislate in their state, and therefore using a constitutional argument is inappropriate. At the district level, Roe wins. The Supreme Court decides in a 7-2 vote in favor of Roe.